We'll open the hearing on Senate Bill 430 relative to mandatory disclosure by school district employees to parents and legal guardians. And I recognize the prime sponsor, Senator Lang.
Thank you, Madam Chair. I am Senator Tim Lang, and I thank the committee for having Tim Lang Education Policy and Administration Day here in the state in Granite Place. This might be a little bit of a deja vu. We passed this bill last year. The outcome, though, didn't end up rosy because on the House floor, I apologize, they added 3 floor amendments to it, one of which created a financial penalty, which the Senate refused to agree with, and the House refused to remove it. So we ended up in a non-concurrent situation, and the bill died. So we're back at it today with a similar, same, a little bit different bill. The only difference in this bill, compared to what you had last year, was Section 3, which creates some rulemaking authority for the Department of Education. But I'll quickly run through the bill for the people that weren't here last year. In Section 1, it's pretty straightforward. This is a process bill. This is to create a uniform process statewide for how parents and teachers will be engaged with each other and have communications with each other. So in Section 1, the Senate did amend this and added the language "and legal guardians," because nowadays we have a lot more people who have custody of children that aren't necessarily the parents. The first one is really simple. When a parent or legal guardian submits a written request to a teacher about information, within 10 days, the teacher must answer in an honest and complete manner. There's been some conversation about completely and honestly, and what does that mean? And I'm pretty sure people with a bachelor's degree, a PhD degree, can figure out what honestly and completely mean without having to have a spoon-fed definition to them. The second part, we do recognize that some information may create a hardship for a child, and so we create an escape clause in our in Roman numeral number 2, and it says that if the credential holder in answering the question feels that it will put the imminent risk or physical harm, abuse, neglect, that credential holder is entitled to withhold that information. But I postulate that a child who a teacher thinks is at risk is at risk. Right? That risk exists because that parent can find out that information in any way, shape, or form, and that child would still be at risk. So again, if a teacher or credential holder, I should say, thinks that the child is at risk, they file the appropriate paperwork, Department of Human Services, saying this child's at risk for disclosure, for abuse because of disclosure of this information or their situation. Again, my argument would be, again, that risk exists whether the teacher tells or not, and the parent could find out any other way, in which case that child is still at risk, so the teacher should disclose. Again, Section 3 is about rulemaking, and Section 4 is where we had some disconnect between the House and the Senate in the violation. We want to make it just a violation of the ethics, and an investigation will occur and find out if they violated the code of ethics, and then they can make the appropriate determinations for what penalties may or may not exist, or find out that didn't violate the code of ethics. It didn't occur, and they're able to do that. So this is a process bill. They're going to hear a lot of testimony about a lot of other topics, but in the end, this is a straight process bill. When a parent asks a question of the school, they should get an answer in a reasonable amount of time, and the answer should be honest and truthful. Anybody who's arguing they vote against this bill is arguing against that concept, that parents don't deserve a timely answer and they don't deserve to be told completely and honestly what's going on. So, and I'm happy to take questions. Okay.
Are there any questions? Representative Balboni?
Thank you, Madam Chair, and thank you for taking my question. Last year, we passed the Parental Bill of Rights, 189B4, and listed on Section E, one of the rights is to inquire of the school or school personnel and promptly receive accurate, truthful, and complete disclosure regarding any and all matters related to their minor child, unless an immediate answer cannot be provided when the initial request is made, in which case the answer shall be provided no later than 10 business days after the request. This is already in law. Why do we need this?
Great, thank you. There's no escape clause in that language at all, is there? So if it is going to put a child at risk and the teacher believes it's going to be put a child at risk, there's not an escape clause in there, in that what you just read me. This would provide an escape clause for educators, for credential holders. Let me be clear. I keep saying educators, it's credential holders.
Any other questions? Representative Cornell?
I don't know what written inquiries, can it be just a blank written inquiry, or does it have to be a specific, like as a guidance counselor, a parent would write to me and say, has my child been coming to talk to you about anything at all? And I have to answer them, yes, they have been talking to me about, or do they have to ask me specifically? Are they telling you, what are they telling you about what's going on at home?
Thank you. So let me answer that question this way. So I have 4 children. I have 2 girls, 2 boys. I got girl, boy, girl, boy. In my relationship with each one of those children, there's been points in time where I have a phenomenal relationship with my children, and they tell me things I wish they didn't tell me. And then I have other parts of our relationship where that's not so much true, that there's a disconnect for whatever reason. If we're in that ebb and flow, when we're in the ebb side, where the relationship may not be that great, but I recognize something is going on with my child, that something is happening. I don't know what it is. I've asked and I get, everything okay? It's fine. Anything going on? No. And I get the one word answers from your teenage child that you sometimes get. But I know as a parent, something's happening. Who is the next most likely person to know what's going on in that child's life besides the parents? And according to everybody, the next most trusted person is the teacher. So why is it not reasonable to have a parent go and ask a question like that? I recognize something's going on with my child. Are you aware of anything that's happening? Right? That's mental health, right? That's what we're talking about, is providing good mental health services, having parents who recognize there might be something going on with their child, asking that next most trusted adult, and hopefully getting an honest and complete answer into the relationship. And I don't know what that answer could be. I have no idea, because every situation has a million different variables to it. But that basic concept, should a parent be able to ask the next most trusted person in a child's life, is there something going on that, because I recognize something's happening with my child? And to think that we would not tell the truth on that, to me, is a bad precedent.
Representative Woodcock?
Thank you, Madam Chair. Good afternoon. I'd like to go to line 13, if I may, and go to the conjunction. And when you were talking about the escape clause, and I'm reading that, and may withhold only information that creates the risk. Is that withhold that information from the parent, or withhold that from DHHS? Or from whom? I know it's in a DH. It's in a DHHS section 2. Yeah. But is it talking, and we have the comment in the end specifically about that, or that is the escape clause you're talking about? They may withhold the information that creates the risk.
So thank you for the question. So again, if you read the section in whole, right, the first part of the section that says, again, if in a good faith determination, such a complete and honest response to the request would put a student at imminent risk, right? That's what we're talking about. That's the information, right? So withhold the information is from the parent because it's creating a risk. Okay. So, but you would have to disclose, because you have to disclose what is your basis for determination of an imminent risk. And it would be, this is the information, and this is what I've been told, believe, the child said that if you tell my parents this, they're going to kill me, right? And if the teacher believes that is a credible threat, they have an obligation to report, and they should report that. And so it's a combination of what are you withholding and what's the risk that creates. That's if told what it creates. So you would have to disclose to DHHS both the information and that's creating the risk, and then the risk itself.
Well, Madam Chair. So I remember when you opened about talking about people with BSs and PhDs and those things, that they can understand what's reasonable. So someone who has an education and understanding of youngsters, they could create, they're determining, as you said, what's reasonable. So if they believe it's reasonable to withhold that information, that would be the escape clause, right?
As long as they did the reporting that's required.
Well, they wouldn't have, based on, okay, question, just, that's all. Based on that, that's why I asked before if that was just DHHS, because they wouldn't have to report it because it says they can withhold the information, that's all.
So again, the issue, again, Representative, you read it and hold on line 12, The credential holder shall file a report. So it's a shall. They have to file a report. The withhold information is from the parent. That creates the risk.
So that's the parent. Okay, thank you. That was the sound that was asked initially. Thank you.
Any other questions? Representative Hall?
Madam Chairman, thank you for taking my question. Do you believe that students have any rights at all in these type of situations? Do students have rights?
I think students have limited rights. Right. So again, I go back to a situation, we'll use mental health because it's probably the thing that's going to cause the most conversation. If a child is going to harm themselves, they're not going to do it at school. They're going to do it at home. Right. And so if you withhold information due to a right of the child that results in the child going home and harming themselves, and you knew that the child was struggling through something, and the parent then asked you a question, the parent can't be on the lookout for the problem that might be occurring at home beyond the fact that I'm getting one-word answers from my child, right? They may put a little more scrutiny on the child to make sure that if they're struggling through something because the teacher told them, they can watch that child and make sure the child doesn't hurt themselves, right? But if you don't tell the parent can't watch for the signs of self-harm.
Thank you.
Any other questions? Representative Parental.
Yes, thank you very much. As sort of a follow-up, so students have a right to be safe from abuse. So the way that I'm reading it is that if the credential holder reports to DCYF that they think the child might be at risk of abuse, then that is making sure that the right of the student is upheld.
Absolutely
Am I
right.
reading that correctly?
Absolutely.
Representative Balboni?
Thank you, Madam Chair, and thank you for taking my question. Last year, we also passed a bill related to amending the Teacher's Code of Ethics that included a responsibilities to parents section. So isn't this rather jumping the gun? Because the way where this is placed in the law is placed in the section that's pertaining to dismissal of teachers. I mean, that's the segment that you put it in. So it's clear you referred to this as an escape clause, but it actually is in a section that is talking about dismissal of teachers. And that would be the 189 section 189. So isn't
I'm sorry,
it
can you
pretty
tell me
much
where in my bill I'm going to 189? In my bill?
in your bill, the section is placed, amend RSA 189, by inserting after section 13C, the following new section. So that 189.13 is the section pertaining to dismissal of teachers.
189.13D deals with communications between teachers, parents, and legal guardians. That's what that section is titled. I don't know about dismissal, but this is a new section that's created, and it doesn't necessarily relate to the one above it, other than the code of ethics components that may be required under dismissal. I haven't read that section. This is a brand new section of law that is relative to communications between teachers, parents, and legal guardians.
I just follow up, please. So again, we already have in place that there is rulemaking going on, I assume, pertaining to violations of the code of conduct relating to parents. And these parents' rules have not yet been established. It seems to me that would be jumping the gun in terms of putting this in, and I do not really see this as an escape clause.
I don't think there was a question there, it was a statement, but okay.
Any other questions? Oh, Representative Freeman?
Thank you, Madam Chair, and it's so nice to see you again, Senator Lang. It's been a long time.
Last night, school board meeting.
Based on this bill, and if a student is being abused by a girlfriend or a boyfriend, and a parent inquires to a credential holder, and the credential holder is aware of that situation, would this law apply to that scenario?
So I think this law would apply, but again, I think there's also the basic mandatory reporter for abuse would also apply, right? So they already have an obligation to report.
Follow?
would you agree that the mandatory reporting has to be to HHS, but this bill would allow that information to also be conveyed to the parent?
Yes, I guess in a short answer, yes.
Any other questions? Seeing none, thank you very much.
Madam Chair, you're gonna take a break because I have to go to a caucus meeting from 12:30 to 1:30. So I'm trying to decide what my time looks like here.
So we're gonna take some testimony. We will take a break at 12:30, come back at 1:15, finish this up, and then get the other one started.
Thank you.
Is there anybody, before we take testimony, is there anyone that can't be here until 1:15?
4:34.
Okay. And we will time the testimony at 3 minutes. And Amy, I'm gonna mess this up. Teravecchi?
We're running our schedule based on his.
No one can pronounce it, so don't worry. Amy Teravecchia with 603 Equality. Thank you. So my opinion today, I'm speaking in opposition to this bill. My opinion today is informed both by my experience as an advocate and also as a mother. I have several concerns with the bill, which I hope to lay out for you. Educators and educational institutions should not be a pathway for parents to understand a piece of their child's personal identity. It creates a concerning and dangerous precedent, placing public schools in a role of surveillance. Schools should be a place of learning, an environment for studying both curriculum and a place of critical self-examination. Placing educators into a role of monitoring and reporting removes the trust necessary for a thriving academic environment. And of course, educators are also already mandatory reporters. So if there is a risk to the child's well-being, they have to report that to DHHS. SB430, if signed, would also be detrimental to building trust between child and parent. It removes the opportunity for parents and children to build trust within their own relationship by having an open and honest conversation. And there's been ample research that shows that children who have big or difficult news to share with parents tend to have better long-term outcomes when provided with opportunities to share that information with them directly and on their own timeline. And although SB 430 references RSA 169C30 in order to grant protections and safety to children at the center of these requests, risks inside the home are really difficult to ascertain for educators. So it puts at odds the threat of investigation and punishment that an educator may face for failing to comply. And it, again, puts educators in a role of detective. The public school system into a role of surveillance in order to properly enforce SB 430. This means educators have to monitor not only student behavior, but also parental behavior and beliefs. And the procedure outlined in the bill creates a dangerous roadmap for those working within the school system that will jeopardize the well-being of students and children, create uncertainty, and inspire a culture of surveillance. For all these reasons, I urge you to recommend SB 430 ITL.
Thank you. Are there any questions? Seeing none, thank you very much. Don Wells?
Mr. Mills indicated that he needed to leave, and I urged him to submit written testimony to the chair.
Okay. Jay Hawkins? I think that's it.
All right. Thank you to the committee for hearing me today. You're read to all day. I'm just going to speak to you as a human. I'm Jay Hawkins. I live in Concord. I've had the retaliatory side of this ban happen to me. When I was in middle school, I was bullied by a teacher and a student. That teacher got in trouble for that. I had a conference with the other teachers in my grade as well as my parents. In retaliation, that teacher told my parents that I was gay. Had I ever told anyone that? No. Did I know that to be true yet? No. He was angry and wanted me to get punished too. That retaliation responded with me having my teeth broken by a family member and being put in conversion therapy. I wouldn't wish that on any human on the planet. It's one of the worst things I've ever been through. I spent a year of my life wanting to die for something I didn't even know was true. It took years to get to the point that I felt okay being a human being that was alive. I understand that there are a lot of things that parents need to know. But that's not always the case. When it comes to gender, when it comes to sexuality, there's some things people aren't ready to say yet or may not even know to be true about themselves. Please don't torment people for information they're not ready to give. If it's an abuse situation, that's a different ballgame. If it's a bullying situation, that's a different ballgame. But I didn't get to know who I was told who I was. And I was tormented for a year. I went to a therapist 3 times a week, and they tortured me for a year to make me be straight, and it didn't work. Please don't do this to other people. That's all I ask. Please don't do this to other people. There are exceptions, sure. They don't want to be my side of the exception. That's all I have.
Do you want to take questions?
Sure.
Are there any questions? Seeing none, thank you very much. Nancy Brennan?
Good afternoon. Thank you. We've heard a couple of hard stories, one from the prime sponsor of what could happen, and one from the victim of bills like this. I'm a retired teacher. I'm a parent. Used to be a school board member. So I've seen this from a lot of angles. And I would like to suggest, as I did last year and as several other people did, what happens one level below that there's an abuse at home, or my child might be trying to kill themselves. What happens when a kid comes to a teacher, as kids do, and I taught middle school and high school, and kids come and they say, Mrs. Brennan, my parents they're going to get divorced. I don't know what to do. And they break down in my classroom. And then they say, but don't tell my parents that I told you. They said, don't tell anybody. And I just don't know what to do. And so you comfort that child and you ask, is there somebody you can talk to? Have you got an uncle, a grandfather, etc. And I had it happen with gay kids. I don't know. I want to tell my parents, but I don't dare. Should I wait till I go to college? And so as a teacher who cares about kids, we listen. And I had a particular kid. And I said, you don't feel like you can talk to your father. Can you talk to your mother? Well, maybe. And I said, why don't you think about that? Talk to your mother and see what she says. And the kid did, and it worked out. I mean, the father wasn't great about it, but the mother said, oh, honey, I've known since you were 10. And so the kid was able to come back. But what if that father had called me before the kid got a chance to get himself together? I mean, am I a bad teacher when all I'm doing is listening to a kid who needs a listener? I really think you need to look at the situations like the one we just heard, but also down the line, if that makes sense. Thank you.
Thank you. Are there any questions? Representative Balboni?
Thank you, Madam Chair, and thank you for taking my question. As you were saying that, I thought of another instance where it doesn't stay in the bill. It says either parent could ask. I mean, could there be instances where a child is put in a position where the two parents, as you pointed out, might be divorcing or have differences in opinion, and yet the way I read the bill, if either one of those parents come and ask for the honest and truthful answer, that school teacher or a professional would have to give an answer. Is that the way you also read this bill?
Yes, absolutely. In fact, we had a situation at our high school where a parent said their child could not date. I mean, we knew it. The kid told other kids. She'd talk about it because everybody was going to the dance and she couldn't go. She wasn't allowed to date. And we knew there was a kid at school that they liked each other, but we didn't call and ask. Nobody asked us. One day, the father showed up, and the kids happened to be standing outside one of their cars holding hands and talking, and the father ran up and decked that boy and then yelled at the teachers, you know, you should have known my daughter's not. Now, he hadn't told us, call me if my 17-year-old holds anybody's hand. But, now that might be one that you had to talk to HHS about. I certainly would hesitate on some of the kids I talked to. I wouldn't call HHS over a father who might be upset that his kid was gay. I mean, I'm not going to call HHS over that. The other father I might have called on had I known the situation. And by the way, and I don't know if this is coincidental because very often these bills, you know, have letters, but if you look at this bill, HATE are the first letters of the subdescription, and maybe that's just a coincidence. I don't know, but you know, it doesn't feel helpful. Maybe it's a coincidence.
Any other questions? Seeing none, thank you very much.
Thank you.
And we will take a break until 1:15.